Taylor Swift, Blake Lively, Justin Baldoni. 3 names you usually see on red carpets, not court filings. So when headlines suddenly claimed Taylor was about to be dragged into Blake Lively's explosive lawsuit, the internet lit up. People imagined Taylor marching into court, taking the stand, and dropping career-ending testimony like a scene from a legal drama.
And the entire fight becomes about deadlines.
This isn't about friendship or betrayal. It's about leverage. It's about deadlines, paperwork, and using the world's biggest pop star as a pawn on a discovery chessboard. And if you think
that's how
this
modern
is about
judges
Taylor
think about
picking
these
sides,
asks.
you
Keep
might
it
be
tight,
missing the
keep it
real game
productive.
entirely. The spark that set this off came quietly. One legal team filed a notice saying they needed more time because, they claimed, Taylor Swift had agreed to sit for a deposition. Sounds huge, right? Except her lawyer immediately fired back. Not true. She hadn't agreed to anything. In fact, she would only appear if a judge forced her to, and even then her availability was extremely limited due to prior commitments. That single word, agreed, turned into the battlefield. Was it an actual commitment or just a hypothetical? Suddenly the whole conversation shifted from facts to optics, from Taylor's going to testify to wait, is she even involved? And that's your first clue that this fight isn't really about getting answers from Taylor, it's about the pressure her name creates. Here's the thing, Taylor wasn't managing the set. She wasn't HR. She didn't run the studio. Her involvement was creative and cultural, not operational. So what could she even be asked about? At most, whether she had private conversations about issues raised in the lawsuit, or if anyone tried to use her influence to sway decisions. That's it. No secret tapes. No bombshells. So why fight to get her under oath? Because just announcing you want Taylor Swift on the record sets off fireworks. It pushes the story out of the legal section and straight into the bloodstream of pop culture. It forces the other side to spend time, money, and energy on a side battle. Even if she has nothing to add, her name changes the math. It's not about her testimony, it's about the leverage her presence creates. On Blake Lively's side, the strategy is surgical. Keep discovery contained. Focus only on witnesses with direct knowledge. Crew, production staff, HR. Push the court to deny what they'll call celebrity spectacle tactics. Frame this as a serious workplace case, not a Hollywood circus. Baldoni's side, the opposite. Expand the calendar, pull the spotlight in. Argue that Taylor's orbit touched the project, so she must be relevant. Even if they get nothing from her, the move itself slows the clock and shifts public narrative. To them, Taylor isn't a witness. She's a pressure point. One that can reshape headlines, and maybe settlement talks. But here's the thing. Judges have seen this game before. Courts hate dragging in celebrities who aren't core to the facts. They have a high bar. You only get a non-party witness if they have unique, non-duplicative information that can't be found anywhere else. Judges usually say, check the emails first, depose the producers, talk to HR, crew, the people who actually controlled the environment. Only if those routes point straight to Taylor as the sole keeper of a key fact would a court even consider it. And even then, the court can lock it down, time-capped, topic-limited. Possibly just written questions, under a protective order. It's not the dramatic showdown people imagine. It's more like filling out a very strict form. To understand why this matters, zoom out. This lawsuit started with accusations of serious misconduct and retaliation. Baldoni denied it. The case expanded as new witnesses and communications were added. Eventually, a trial date landed on the calendar. The court's way of saying, enough delays, finish discovery. So trying to pull in one of the busiest stars on Earth at the tail end of that schedule. That's not just a legal move. That's a scheduling gambit. If you can blow up the calendar, you reshape the whole case. That's why this fight is as much about time as it is about truth. Mentioning Taylor's name isn't just legal noise, it sends shockwaves through the ecosystem around the case. Jurors see the headlines. Studios, insurers, distributors. They start calculating risk differently. Agents and sponsors start quietly asking questions. This isn't just about evidence, it's about perception. And perception can shift leverage and settlement numbers faster than facts. Meanwhile, every new motion costs money. Every scope fight spawns more legal hours. Every extension opens more space for gossip and chaos. Tempo becomes everything, and Taylor's name is the kind of grenade that scrambles tempo instantly. So what happens now? Most likely the judge says no, or gives a razor-thin approval, maybe an hour of questions, only on a few specified topics, under strict limits. Possibly done on paper, with lawyers editing the questions beforehand. Least likely. A broad, open-ended grilling. Modern judges rarely reward spectacle tactics that delay the main case. If it happens at all, expect a calm transcript that sounds like scheduling emails. Yes, I attended that call. No, I don't recall who raised that. I was told after the fact. No bombshells, no viral moments, just logistics. So where does that leave Taylor Swift right now? Exactly where her lawyers want her, framed as a non-party with no unique info, refusing to volunteer, prepared to comply, only if forced, available, if at all, in a tiny window between her global commitments. That stance protects her brand, fits legal norms, and quietly drains drama out of the request. If she never sits, the story fizzles. If she does, it's unlikely to matter. Because at the end of the day, she's not a star witness in this case, she's a strategic variable, a name on a calendar, not a bombshell on the stand. Here's the part most people miss. If you want to know how this ends, don't watch for paparazzi photos of Taylor walking into a law office. Watch the court docket. Look for 3 words: granted, limited, denied. Those words, not headlines, will tell you everything. They'll tell you which strategy the court is rewarding and whether this case is heading toward trial or just spinning into another pop culture content cycle. Taylor Swift might be the biggest name in the file, but in this story, the real power lies in the small print. And when that ruling drops, you'll want to know what it really means, not just what the headlines scream. So, this might feel like a strange, isolated drama. Taylor Swift randomly pulled into a legal storm that has nothing to do with her. But here's the truth. This tactic isn't new. High-profile lawsuits have a long history of trying to rope in celebrities, not for their knowledge, but for their gravity. And that brings us right back to where this started. The real battle here isn't happening in headlines, it's happening in scheduling orders and discovery deadlines, which leads directly into your original conclusion about granted, limited, or denied. Hit subscribe, stay tuned. Because this battle isn't about who's the loudest, it's about who controls the clock.